So you said that the courts are eventually, maybe with everything, that they will say, okay, this is a genocide, and they will find Israel guilty, so to speak, right? So we have seen over and over again, there's lots of resolutions, there's lots of decisions, but nothing happens to Israel. So
Yeah.
if the courts say, okay, they're guilty of genocide, so what? So what? Well,
Yeah, I
what
think-
does
I
that
think-
do?
Absolutely fair question. And I think the answers are different for the ICJ, the International Court of Justice, which is part of the UN system, the so-called World Court that has been in existence for a long time, that has the most respected jurists in the entire world sitting on it as a panel of 15 usually. Sometimes more can be added. I think the weight of their opinion will be great. Particularly now, there is their judgment on their 2024 advisory opinion judgment on the legal status of the occupation, and they found that the occupation was completely illegal in its entirety. It's not just that specific actions like the settlements and the like are illegal. It's not just that torture, et cetera, et cetera. It's not the discrete, the entire occupation is illegal. That's really a pretty strong finding. And it has not been, obviously, respected by third parties. By the way, the opinion, the advisory opinion, went into considerable depth about the obligations of third-party states not to enable this illegal occupation, which clearly has been ignored, right?
Yes.
That was an advisory opinion, however. Israel did not appear in that case, didn't argue in that case. The South Africa versus Israel is a case in which Israel is a party and has appeared to defend its position. And I think that puts it in a little bit different status. I think this is going to create a huge dilemma for those states which, primarily Western European states, that actually understand the importance and the value of international law. People in the United States, we've never, that is non-native people, the settlers of the United States, have never experienced a world war the way the French and the Dutch and the people of the continent and even the UK, they've all experienced what it's like to go through a world war. That's what produced the post-war legal order. They know and still value international law. And so they're going to be placed in an extremely difficult position once this finding is made. And I predict that with public opinion throughout the global north also having shifted tremendously over the last several years as a reaction to the genocide, that people are going to start finding the political will and spine to do what's necessary to begin to enforce the findings of the court. So, international law findings can be ignored by the powerful. They have been in the past. U.S. and Nicaragua completely, the U.S. just blew off that finding, ignored it. But over time, and between the interaction of civil society and governmental authority, I think these judgments are going to make a difference.
I want to raise a point. In 2018, I published an article in the Albany Government Law Review titled "The Anglo-Centric Supremacy of the Marshall Court." It was a 50-page article that looked at the contradictions of the court when dealing with indigenous peoples.
Yeah.
And that is a concern when we have an indigenous people that, even with the World Court. If you look at the United States, I'm sure you're familiar with the 7 Major Crimes Act.
Yes.
And so even the title, 7 Major Crimes Act, that was placed on indigenous people, where those initial 7 major crimes, one of them is intent to commit murder. That would put an indigenous person in jail.
Yeah.
Intent for carnal knowledge. I mean, these were all just intents. Intent to commit robbery. So I occasionally would say in a classroom, you know, if I'm standing with a friend of mine, another Native person, I'm looking in a window and I see a nice pretty blue dress and I go, that would look really nice on my lady, maybe I should come back and grab it. And somebody heard me, that could have put me in jail under the Major Crimes Act.
Yes.
So that article that I wrote looked at all of these contradictions from Marshall all the way up to 2014. When dealing with indigenous people, a court will contradict itself. And that is a real concern.
Yeah. It is a concern. What I would say in comfort, if it is a comfort, is, you know, the ICJ has a pretty remarkable record of independence on this issue and on other issues. And why that is, I mean, first of all, you know, it's old, it's venerable. Unlike the ICC, the International Criminal Court, which is a relatively new creation, founded, you know, a little over 20 years ago. The International Court of Justice has been around for a while. Its system of appointments is rigorous. It ensures diversity of perspective and of legal experience, legal tradition, and you know, so it has power that the ICC doesn't. It has legitimacy that the ICC doesn't. And you know, if you go in detail through the 2024 advisory opinion on the illegality of the Israeli occupation, it's a clean sweep for Palestinian arguments. You know, the judges, and this included American judges, it included you know, Australian judges, it included Canadian, a Canadian judge, one each, I should say. You can't have more than one judge from a country on the court at any one time. They all ruled with the majority. You know, and the majority, it was like, it was 13-2, 14-1, 15-0 on almost all of the points of law. They vote on different aspects of a judgment, so you can have different splits in different parts of a judgment. But this was remarkable. It was like I say, it was a decisive majority in favor of every position argued against the occupation. Will they have the same courage when they, you know, when presented with, you know, with this evidence of the genocide? I think they will. You know, their early provisional measures were an indication, I think, of how seriously they took the allegations. The fact that Israel blew them off and completely ignored them, I don't think is going to endear Israel with the court. I mean, you would still expect them to make a judgment based on grounds of law, not on the fact that Israel has defied them. But it can't have helped Israel's cause. And I think the rising tide of global opinion, even in, you know, in bastions of pro-Israel support in the UK and in the United States, I think it's going to make it politically easier for the court to arrive at a judgment of guilt that Israel actually has committed genocide. I'm one who believes that courts ultimately do reflect politics and ultimately are sensitive to the political context in which they're operating. So, you know, in that sense, I think what's driving courts on this issue is what all of you and all of us have been doing over time, what people in the streets have been pushing for and saying, people even on social media. I think it all of this creates an atmosphere in which courts feel freer to draw judgments in alignment with their values and with legal, actual law.
So I have a question to Pei-Lin. So Pei-Lin, thank you for your presentation, it was beautiful. And you shared a figure about sovereignty, I think, where you mentioned co-stewardship. So could you please elaborate about that, and what do you mean by that? If you mean like co-management, like co-stewardship, I think, and who co-stewards with whom? Because I think Western and indigenous co-management doesn't work well. Thank you.
Thank you for that question. It's a very good one. Co-stewardship, I think, is a little bit more expensive than co-management. In my work with the U.S. government, in government-to-government relationships with tribes, we are moving towards, where it is feasible, co-stewardship practices. I work for the U.S. Army Corps of Engineers, for example, and we are beginning to do certain actions and delegate authorities to our indigenous tribal partners. For example, at the case of a large fish hatchery in northern Idaho called the Dwarshak Fish Hatchery, the Nez Perce tribe is now managing that hatchery and through a formal agreement instrument. And they're doing a fantastic job. They're actually doing things that federal managers did not know how to do. They have certain understandings of what the baseline conditions were for the fishery there and what their desired future condition is. So sometimes it looks just like management, like that, and sometimes it can be a lot larger. For some of the wetlands and other ecosystems that the Corps of Engineers is responsible for managing, we take our trust responsibility to our partner tribes into account here, so that many times trust resources that the U.S. government is managing in trust for tribes under the terms of many treaties and prior case law. When you do co-stewardship practices, which is working basically side by side using federal capacities, authorities, and funds, a lot of times the trust resources improve in ways that they would not otherwise. So we're kind of doing a ground-up approach to it, and we actually, in the Corps of Engineers, have a co-stewardship policy now, which is to do it whenever possible. Of course, it is optional for federal agencies to use the policy where they will, but because the Corps of Engineers has tribal liaisons who work with our other managers, I think we're pretty proactive on it. I think it should be required rather than optional, but it is a step in the right direction to have a policy that we can actually refer to when we're talking to our leadership about these kinds of arrangements, and including pretty hefty funding for tribal staff to engage in co-stewardship for some of these resources. So it's kind of a long answer. I think that co-stewardship maybe is a term that's worth exploring more in a separate paper, because it has a lot of different levels. And as you pointed out, it doesn't always work, especially if it's discretionary. But we're working on that and working away at improving and growing out some of the leaves on the tree there. So I'm really glad you asked the question. I hope I gave you a reasonable answer on it.
Thank you.
Cindy, did you have a question, Cindy?
I was going to make a comment on George's presentation, but I look at my watch and it's lunchtime, so I have to keep everybody much longer. I withdraw my comment.
Okay. All right, we'll break for lunch, come back at 5 minutes before 1, so that we can start at 1.
My watch is off?
No, I want people back at 5 minutes before 1. Here in
Hey,
Montana.
Katerina, I see your question in the chat just now, and I'm sorry I didn't see it previously. If you want to send, give me your email or whatever, I will respond to you directly.
All right, I'm going to close this down, which means I think we have to log back in after I close it down. Or I'm going to stop the recording, that's for sure. Let's stop that. Or I could leave it open, actually, and just let it turn on. Let's do that so people won't have to log back in. I'll just leave it on, and we'll just go to lunch and come back in an hour.